Hello everyone, my name is Carol Westrop and I'm in the General Counsel team of the SRA, and I'm today joined by my colleague Oliver Sweeney, who is one of our heads of legal and enforcement. And we're both very pleased to be able to talk to you today about some of the work that we're doing in the SRA around the themes of well-being in relation to the individuals and the firms that we regulate. Now, issues about well-being in the legal profession are really common and important at the moment. Some of you will know of some of the recent STT cases that we prosecuted. These are matters before the Independent Solicitors Disciplinary Tribunal, which have brought into sharper focus for us some of the issues around well-being in the profession and the importance of firms having a culture and systems and controls to prevent bullying, harassment and discrimination in the workplace. So our talk today will explain our approach to some of these themes and issues and why it's an important issue to us at the SRA, and in effect what we're doing to understand the impacts of this on the work that we do. So we're going to talk to you about some of our joint initiatives and working that we're doing, and also that we will be proposing some new regulatory guidance, which Oliver will talk through you in due course, about some of the issues that we're taking forward, and when we might take action for a serious breach of our requirements. But first, for those who don't already know this, I'm going to talk to you a little bit about the SRA's codes and principles. So many of you who work in legal services and are regulated by the SRA will know this already, but we have 6 core principles that underpin our fundamental ethical tenets, and these apply to all the individuals and firms that we regulate, both inside and outside of practice where the context requires. And one of the key ones is upholding public confidence in the solicitor's profession and those that deliver legal services. And our principles are supported by our codes of conduct, one for firms and one for solicitors, registered European lawyers and registered foreign lawyers. And our codes, for example, our code for firms, require firms to have in place effective systems, controls and arrangements to make sure that both the firms and their staff can comply with the SRA's regulatory requirements and legislation, as well as managing all material risks to the firm's business. And as the introduction to the Code for Firms explains, these aim to create and maintain the right culture and environment for the delivery of competent and ethical legal services to clients. And paragraph 4 of the Code for Firms also includes requirement on firms to ensure that their staff are competent and that they keep their knowledge and understanding of their legal, ethical and regulatory obligations up to date. And firms also need to have a proper systems in place for supervising client matters. Now, we already do a lot of work in the SRA to encourage equality and diversity and inclusion in the solicitor's profession, and that's also one of our core ethical principles. We know that firms which support EDI issues often do better on well-being issues. They have a more inclusive culture that is driven by leadership at the top, which obviously is important. Now, we set about our expectations on equality, diversity and inclusion in on our website in a number of dedicated web pages. And these provide a lot of further and helpful resources which will signpost you to other organisations such as LawCare, the Solicitors Assistance Scheme and the Law Society, all of which are doing a lot of great work in this really important space. Now, some of the work we've been doing on EDI initiatives over the past year or so, which supports and underpins well-being issues in the profession, including publishing some top tips and case studies which follow our research into disability inclusion. And this highlights the link between having an inclusive workplace and well-being issues for staff and the wider health issues this involves. And discussing what more firms can do on race equality. And this has been led by a series of webinars led by our chair, Anna Bradley. And this includes many voices from the profession following on from the murder of George Floyd last year and the impact this might have on black, minority and ethnic members of our community, and particularly against the backdrop of the pandemic over the last 2 years or so. We're also continuing to support our EDI mentoring scheme, and this aims to put firms which have experience in these issues regarded as leaders in the fields of equality, diversity, inclusion, with smaller or medium-sized firms which can learn from them. And we've recently done a sort of a webinar where we put these firms in contact, particularly on well-being themes. And finally, because data supports better understanding of these issues and helps monitor trends, we're continuing with our ongoing mission to encourage better reporting of diversity issues in the profession. And we're doing that through our My SRA, so those of you who are regulated directly by the SRA can input data about your diversity, your background, your social mobility, which we're now are looking to include, as well as protected characteristics, and that will help inform our approach. And we're also, biannually, we collect firm diversity data, so this is from the firms that we regulate, and they are required to report to us about diversity data. And we've just got that back, and we're going to be unpicking that and looking at what that tells us. So we'll be coming back out with some reports and research on that data. We'll say that we're particularly interested in disability and reporting of disability. We know that only 3% of solicitors or lawyers working in firms that we regulate report that they have a disability, compared to 13% of the community as a whole. And we really want to understand why there is underreporting and what that means for inclusion in the workplace. So that's a bit about our principles, our codes, and our wider EDI work. And I'm now going to let my colleague Oliver talk to you a little bit more about our general approach to well-being.
Thank you, Carol. Good afternoon, everybody. The first thing I'm going to talk about, I'm afraid, is a little bit about the COVID pandemic. I'm sorry to have to mention it again. But it obviously has an impact on well-being. We appreciate that the practice of law is quite stressful and can be quite stressful in normal times, and we appreciate that can be exacerbated, and probably has been exacerbated by the pandemic. Now, last year, the charity Law Care reported that over a third of their contacts related to COVID-related issues. Now, that could include social isolation, worries about lack of supervision, or other mental health issues. And those concerns have also been underlined by their recent report released on life in the law. Now, one other statistic from that I did want to highlight and mention was that over 20% of participants to that survey said that they had experienced workplace bullying, discrimination or harassment, which is of course quite concerning. And linked to that is the equalities impact that has, because those behaviours are more likely to impact on women, people from an ethnic minority background, or those with disabilities, and that's the theme that we're going to return to later on in this talk. So, just coming back to COVID, from a regulatory point of view, we haven't at the moment seen a lot of reports or complaints specifically relating to COVID impact or COVID-related issues, which would suggest that law firms have, by and large, responded fairly well to the challenges of the pandemic, including very swift moving to home working, and also the need to support staff members who may be feeling these impacts of isolation. However, I think we can all agree that there is an increased risk of stress, anxiety and burnout related to this, and in particular that may be exacerbated by a lack of support or supervision. So it's something we're going to keep a watching brief on, and it's possible that failings will come to our attention in due course. Something on this note that we are aware of, and we hope firms are also aware of too, is that the pandemic may have had a disparate effect on different communities and different groups. So, for instance, those who have pre-existing health issues may have more concerns about the return to the office and plans for a return to the office. Conversely, there has been some benefits to some from the introduction of more longer-term flexible working and remote working arrangements. So, getting past the pandemic, which we will be pleased to do, moving to our enforcement work more generally, we think, seen an increase in health issues and well-being issues and workplace stress issues being reported to us more generally, and quite often in response to investigations that we're doing already into other incidents. Now, in relation to that, our enforcement strategy does make it clear that we're unlikely to take action where something is an inadvertent error or an honest mistake. So when things do go wrong, we of course want to look into the background and the context for that, and part of that is going to be to try and understand why people have behaved in the way they have, and their motivations. Part of that, of course, is the environment in which they're working, any stresses that they have been subject to. So we generally want to look at that, we want to take that into account. It does become more difficult at the sharp end when what we're looking at is essentially a cover-up over a period of time. So in that context, you'll probably be aware of cases that we've brought before the Solicitors' Disciplinary Tribunal, which have involved allegations of dishonesty, sometimes by junior solicitors, sometimes involving shredding or fabrication of documents to cover up mistakes, sometimes involving lying to clients to tell them that matters have been resolved when they haven't, vice versa. And those are quite serious issues, because the existing case law and precedent does state that where there has been findings of dishonesty, the usual consequence of that will be that that person has to leave the profession. Now, notwithstanding that, some of these cases have involved cross-allegations, as mentioned, of that they are working in a toxic working environment. Now, these allegations, whether we receive them in response to such incidents or otherwise, they can range from people whose managers have repeatedly failed to make reasonable adjustments when requested, where managers have belittled staff in public, where individuals are required to take on volumes of work outside of their competence without any support, and where firms have failed to act on reports of bullying, discrimination or harassment, and essentially have tacitly encouraged that happening either by specific individuals or the firm in general. And where we get these reports, we are going to be concerned, we are going to want to investigate and take enforcement action where appropriate, because we recognise that these issues can contribute to workplace stress and ultimately potentially also impact on client work. In this respect, I think it's worth noting one of the stats from the Junior Lawyers Division's 2019 report. Now, over three quarters of respondents to that report thought their employer could do more to provide help, guidance and support in relation to mental health issues. Lastly, I do want to mention that we also have a part at the SRA to play in this and in wellbeing, particularly in the context of the impact that our investigations can have on participants in those investigations. Now, of course, our investigations are necessary to uphold public confidence in the profession, but we recognise they can be a significant source of stress. One thing we've done in this regard last August was to publish a document about how we look at mental health and health evidence more generally in the context of our investigations. And that document sets out what it is that we really need from respondents in terms of evidence about their health, whether that be that their health has an impact on the original incident that we're investigating, or that it's going to have an impact on how they can participate in proceedings. And the idea is that if we do get evidence of that nature and quality, we can take that into account in how we progress things through the tribunal, or indeed in certain circumstances it may support us to come up with an alternative disposal, such as a regulatory settlement agreement or appropriate conditions to manage risk. So I'll pause there and return you to my colleague Carol, who's going to talk to you a little bit more about the sort of things that we're doing at the SRA to address these issues.
Thank you, Oliver. So I'm going to talk to you just shortly about what are we doing about some of these themes in our work, and what are these new initiatives that we've got underway. Well, first of all, we'll continue to improve and promote the information on our website. For those of you who've perhaps listened to some of our other talks today, we do have a lot of resources on our website that we hope are helpful to you. In particular, we've got a section on your health, your career, which sets out a lot of information about our approach to health issues, including the increased stress that we think those we regulate are under and have been under during the pandemic, including publishing guidance from Law Care about what can you do to thrive in the law. Just to say here that we know that we can do more perhaps to improve our website and help you navigate around and to group things in a slightly more coherent way, and that's very much something that we're working on at the moment, so work in progress. So we set up several months ago a cross-SRA working group, and that's to coordinate the work that we're doing around wellbeing issues, stress, discrimination, bullying and harassment, equality and diversity issues as well, to make sure that we've got a joined up approach within the SRA, with our enforcement work and also with other experts and regulators in the field. And we've been coordinating our cohort of cases which raise these themes, so where we've had reports to us or complaints of bullying, harassment or discrimination. And we've got about 50 of those cases currently under consideration, and some of these dovetail in with the allegations that we might have received in relation to sexual misconduct as well. And we've been using these complaints to inform our thinking going forward. So how can we develop our guidance, our approach, and make sure that we have a consistent, informed approach going forward? So some of the things that we've also been doing is we've just in the middle of doing a thematic review, and this is being led by our risk and research team, which are experts in these areas, on firm culture and how this impacts upon the wellbeing themes. The review commenced in June 2021 and will run until the end of this year. So phase one involved us talking to some sort of key stakeholders, so the junior lawyer division, law care, some firms. We used a questionnaire to elicit some high-level responses. And that's really about the procedures and processes they have in place around workplace culture and wellbeing issues. And phase two, which has just concluded, involved us taking a real deep dive with 10 firms of varying sizes, and asking in more detail about their approach to these issues. And that involved us talking to both senior leaders and also more junior staff who might be subject to these issues within the workplace. And the proposed outcomes of this piece of research, which we hope will be delivered in early 2022, will be publication of research paper, but also development of a toolkit and other sort of more best practice initiatives to help us drive good standards in this area. We've also been working with other legal services regulators. You will know that there are 7 legal service regulators across a wide variety of different legal professionals. So we've been working with particularly the Bar Standards Board, which regulates barristers, and SILEX, which regulates legal executives, with the assistance of law care. And we've been talking to them about how we have a sort of consistent approach to these issues insofar as we can. What's a common view of what bullying might be, for example, so when perhaps some difficult issues around robust performance management, which happens in most firms, might tip over into unacceptable levels of bullying. And should we have similar information on our website, and how can we learn from the complaints that we've received and share examples of our approaches to make sure that we share learning in these important areas. So that's very much an ongoing piece of work with us at the moment. And we've also been delivering some guidance, but I'm going to defer to Oliver because he's been very much leading on this piece of work to tell you about how the guidance is shaping up and what that might involve.
Lost my notes. So, as Carol says, we have developed 2 new pieces of guidance, and we're currently in the process of having some targeted engagement with key stakeholders regarding those pieces of guidance. That includes small firms, equality groups, and larger law firms, and we hope, once we've got the feedback from those groups, to be able to publish those pieces of guidance very shortly. The first piece of guidance is some regulatory guidance, and the key point of this guidance is to provide a very clear steer to law firms as to when we will take regulatory interest in complaints that firms have an unsupportive or bullying or toxic working environment. Now, we have to accept that as a regulator, it's not our role to ensure that everybody has a happy and pleasant working environment. We can't do that. Practicing law sometimes can be pressurised, it sometimes can be stressful. However, we are going to make it very clear that that does not justify bullying, harassment, discrimination or victimisation. We're going to take such matters very seriously, and we do want them to be reported to us, so where appropriate we can investigate and take action in accordance with our enforcement strategy. We will remind firms of their responsibilities under the principles and the codes. In particular, we're going to remind them of the requirement to have effective systems to ensure legal and regulatory compliance, and to ensure that they are in charge of their staff's competence and across their staff's supervision. Now, we will also make it clear that we consider that that includes having arrangements to make sure that staff can confidently raise concerns and be supported if they are experiencing problems. Now, in accordance with our enforcement strategy, we obviously say that one-off incidents are unlikely to require regulatory responses. However, we are going to be concerned where we see an unhealthy working environment which is leading to the sorts of regulatory breaches, things like abuse of authority by senior persons in relation to junior persons, complaints of discrimination, victimisation and harassment that are not being properly dealt with by firms, or indeed firms pressurising staff to withdraw complaints or not make complaints. We are going to be clear that we can take action both against firms and individuals who are responsible for this conduct, and we're going to provide a series of case studies which will really illustrate when we will take action and the sort of factors that we'll take into account when assessing what action to take. So that's the regulatory guidance. The second piece is a piece of best practice guidance, and that's going to set out and explore some of the wider issues around the importance of having a positive workplace culture. Now, we're going to talk about why it makes good business sense to have a good workplace culture. It helps with retention, it helps with recruitment of the best people. The guidance will also suggest some simple ways in which firms of all sizes can promote a healthy working environment and a positive working culture. That's going to include publicly outlining your commitment to wellbeing issues, and that might include having a policy on wellbeing and health issues which is implemented. It can include simple risk assessments as to the areas and modes of work which solicitors are engaged in, and also regular staff surveys. It can involve having mentoring schemes, so those schemes could cover not just work issues but also health and wellbeing issues, and really is going to underline the importance of senior leaders leading by example in relation to wellbeing issues. Now that's also going to be informed by our thematic work which Carol has mentioned and the interviews we've had with law firms, and that's going to help develop that into what's hopefully a really useful toolkit for firms in due course. Last but not least, we're also planning to consult early next year on a possible change to our codes, which will include a new provision which will really clarify that individuals should treat staff and colleagues fairly and with respect. Hopefully that is not controversial, but we're going to consult on that in any event. So, in summary, we as a regulator are very much alive to the problems that failures to take care of solicitors' wellbeing can cause. From a regulatory standpoint, there's an obvious problem potentially with whether or not that would promote an inclusive approach to the practice of law, but there's also other consequences which might include risk to professional standards and also ultimately risk to client work. So we are going to be using the tools at our disposal to make sure that firms are ensuring that employers' wellbeing is catered for, and that employees are able to speak up and get support early if they're experiencing any problems. Thank you, and thank you for having us speak today. We've got some time for questions if anyone has any questions. And we'll be sat just here so we can hear them.
I will actually, I'll move the slide on so that to
sorry.
prompt any questions that you might have. I can hear myself now. Does anyone have any questions on these themes?
I have an opening question, if that helps, Carol, for you, if that's all right.
Yes, definitely.
I wondered if you could just talk a little bit more about what other regulators might be doing in relation to including requirements in their codes for respect and mutual respect of employees.
Yeah, thanks, Oliver. This is picking up on your point that we're planning to do a consultation on expanding our requirements in our code to have a requirement on firms and solicitors to treat people with dignity and respect, to make sure that they meet the standards that we require. So we've obviously looked at what other regulators do. Most regulators, whether it's legal services regulators or others perhaps in healthcare, generally will have a specific requirement to avoid discrimination, victimisation and harassment, which is probably not surprising because that's protected by law, but that's something that's quite common. What's less common is perhaps a standard requiring you to treat your colleagues or staff with dignity and respect. Sometimes that's included in guidance, which might be offered to the individuals who are subject to that regulator. But there isn't that much commonality about whether or not there should be actually a standard or a rule requiring this. But we think it's probably something that would be sensible to consider, hence the proposal for a public consultation on the issue. And that's partly to make sure that we really reinforce our commitment and make sure that firms are aware of the standards that we think should be embedded into the workplace. And also perhaps if we did want to bring proceedings, that we've got a an additional standard or requirement that we could say that someone has acted contrary to, and that might assist in our investigative and enforcement work. So for those reasons, we think it's something that we should be exploring. And if any of you are interested in this, I think when you keep an eye open on our SRA's website for when we do issue the consultation, and we would obviously love to hear from you with your views on the standard that we're proposing, and more generally on the issues on the back of the consultation. So that would be really helpful if you could do that.
I was very interested that when you were talking about having guidance notes as well as best practice notes, whether this is a new departure for a regulator to have, as it were, almost a carrot and stick approach, where you're saying, actually, this is good practice and this is what we're encouraging. On the other hand, saying, if you don't do this, we might take action against you. And is it something that could be developed in other areas, perhaps with other regulators or in other disciplines and principles that we issue guidance notes on?
Shall I kick off and you can add to that? I don't think it's new, but the reason there is two is that the regulatory guidance is there to explain how we apply our existing requirements, and we will have regard to it in terms of our enforcement investigative work. So obviously our guidance can't make rules through the back door, but it can be clear that this is something that you need to have regard to when interpreting and applying our rules in practice. The best practice is more of, as you say, more of a softer piece to help guide and to give some ideas. And we do that in some of our other work. For example, in our guidance to reporting accountants on the councils, we have some examples of good practice, best practice that will help, to help firms where they're not quite sure where the boundaries lie. But I think you're right that it's something that we probably could do more of, and certainly linking with other regulators, the Law Society, which does a lot of best practice work, making sure that we're joined up is something that we're quite keen to do. So I think there's definitely a place in us developing more of these kind of best practice to help firms guide their way through some of these tricky issues. Some of the newer issues that we've had to deal with, such as the rise of social media and so on. So yes, I think in answer, yes, it's a good question, and yes, I think there's probably more that we could do. Oliver?
I don't have much to add to that, Carol. I mean, I do think it's useful to be clear the difference between those pieces and their different functions. And I mean, as we said, we hope the best practice piece, when you look at it, will be a really practical tool, which is really useful for firms who don't maybe have enough ideas about how they can ensure their employees' well-being, and they will work together, I suppose, as pieces, because the regulatory piece is going to be more focused on illustrating where we're going to take an interest, but we're hoping one piece will trigger an interest in the other piece.
Hi, my questions concerning regarding SRA policies, regulations. I never see the guidance and policies based upon those training solicitors or solicitors to be in the place of, if anything mistake of law has happened, or any mistake of error been happened from any of the solicitor or training solicitors, never been guided by the SRA authority to give any advance notice. Okay, this is the mistake been happened, can be rectified, or any amendments can be done. So my question regarding this, there is no guidance and policies in this regard. So is it any amendments would be coming in future, or any policies will be amended further? Those who does any mistakes in the professions. Thank you.
I mean, Carol will add to this, but I think there is some guidance around. It depends on the nature of the mistake, basically.
For example, dishonesty.
Yeah, so dishonesty is not a mistake, I think, would be our position.
Yeah,
on this.
but he or she might not be known about that.
Yeah, so I think there's quite a lot on our website around dishonesty and what we do in cases of dishonesty, because I think our view would be that dishonesty is not a mistake. There is often a relationship in some of the casework between people making mistakes and then acting dishonestly to cover them up. And what I think we're saying, and what we really want to happen in the context of this guidance, is for people to be supported if they have made mistakes and feel able to own up to those mistakes, promptly so that they can be corrected, and so that we don't have this sort of dishonest cover-up where there are cases where clients have been misled for years thinking their cases have been resolved when they haven't, or vice versa. And it is that sort of thing is going to be a regulatory casework issue. Carol, I don't know if you
I would just supplement that with a couple of thoughts. One is that we do have clear requirements in our codes about reporting issues to the SRA. So if you're a supervisor or you're working in a firm and you're aware of a serious breach of the SRA's regulatory requirements, you are required under our rules to report them to us. Now, it may be that it won't lead to anything. It may be that we will simply take a note of it, but it won't lead to any investigation or enforcement action. But there is an obligation to report serious matters to us, because in terms of us protecting the public, we need to know really what's happening in firms and if people present a risk and what do we do about that. But picking up on a point which I think Oliver mentioned in his presentation, that our enforcement strategy, which is the thing which sets out our approach to issues of mistakes and inadvertent errors, we're quite clear that we wouldn't take any action on the back of a single mistake. Mistakes happen in all walks of life. People, they miss limitation periods. They fail to file things with the court and so on. And that's why you have professional indemnity insurance, so that if there's a claim, that you have insurance to compensate the client for any losses that they suffer. That's not the same as if there's someone who actually does something that is a risk to the public, a risk to the public interest, which is what, of course, the SRA is there to protect. So there is certainly information on those issues on our website. If there's anything specific that you have in mind, perhaps grab us later and we'll have a chat through later.
Particularly the problems to the solutions. If any solutions made in this regard would be really helpful to those practitioners who are coming further to do the practice, or else those who are in the training period.
Yeah, okay. And I think that's right. I mean, I think we try, our aim is to be is a proportionate regulator, only taking action when necessary in the public interest. So perhaps we can have a chat about your particular example, and then we can get into the detail.
Okay, thank you. Thank you very much.
Okay, my pleasure.
Thank you very much for your presentation. The proposals on well-being sounds good. My concern is human behavior is very complex. And as solicitors, we are not psychologists in a way. You could have a scenario where people have personality clashes, and how do you deal with such issues? Who is right or wrong? Where you tell a supervisee that there are performance issues or attitude issues, and what you get back is, no, you are not treating me with respect. Who reports first? Can the supervisor report and say that, look, this employee or supervisee has not treated me with respect? I don't know. How are you going to deal with such issues? Thank you.
It's a very good question, and I can field this one.
Yeah.
So, it's a very valid question, and it's part of the reason that we thought it would be important in our guidance to include some case studies which will illustrate where that sort of behaviour turns into a regulatory issue, because we are going to be saying, not every case where a solicitor is upset because they haven't got a promotion that they think they deserve is failing to treat with respect. And indeed, we want there to be robust performance management and robust disciplinary management, because frankly that's part of stopping bullying, discrimination and harassment. So we're in favour of that. But it will come down to the evidence in certain cases, and I think what we're talking about where we're more concerned is you see a pattern of disrespectful behaviour across, and maybe it will be one individual treating lots of different individuals disrespectfully, and we will get that through the reports and the investigation we do, and that's what's going to sort of pique our regulatory interest. We will have limited interest in things which are genuinely just, I didn't like being told off because I'd done a bad job in this. That's something which we are going to expect firms to manage, and there are some things that simply won't become serious regulatory issues. because otherwise, I think, as you were saying, we'd be constantly refereeing, disputes over who should get a raise and that's just not our role. So that will be illustrated, I think, more clearly by the case studies we're going to release. So it's a very good question.
See, I've worked with a lot of my friends who have been trainee solicitors, and in the course of their training contract, they have been bullied by the practicing manager. Getting them to work extensive hours over the weekends, sometimes during holidays, and also these trainees have been paid well below the national minimum wages. So how are the SRA dealing with complaints from trainees, or what do the SRA, is there a guideline they have on that, on how employers should treat employees?
Yeah, so I think that's part of the reason we want to publish this guidance and really make sure that people become aware of it, because it is going to illustrate not just to firms but hopefully trainees and other people who might want or be considering complaining to us about the way they're being treated by their firms, to understand what we would take account of as a regulatory issue. Frankly, if a firm doesn't have a system to ensure that it's paying national minimum wage, that's probably something we're going to be interested in. It's quite, and that goes back to what we were talking about, that firms need to have systems in place to ensure legal compliance. The issue of hours is a bit more challenging across the profession, because you'll get the debate over how can the SRA say this hourly target or that billing target is too high. Surely you would have to say that this is the maximum that any firm can do, and you'll get lots of other firms who will say, well, we don't, or indeed some solicitors who say, we don't want this because we do want to work longer hours and get paid more as a result. Now, I appreciate that's not uniform across the profession, but it does make the issue of hours per se more challenging. What I would say, though, is that if a firm of any size is behaving in this way, and that trainees or any employees, any solicitors feel that they're unable and they are not coping as a result of the demands work is placing on them, if that firm does not have a culture which enables that employee to speak up, then that's something we're going to be interested in as well. So firms, I think, will need to be a bit more responsive to employees saying, I am struggling with this, it's just not feasible because of my circumstances or whatever the reasons may be, and we expect firms to have a sensible response to that rather than just shutting that down and saying, no, get on with it. I hope that goes some way to answering your question.
Thank you.
Does anyone have any other questions for us? No? I think that's great. Thank you for those questions. They're actually really, really helpful to hear from you and to hear your thoughts. So we'll take that feedback into account when we're developing the guidance, which as Oliver said, we hopefully will be out at the end of this year, the beginning of next year. So please keep an eye open for that. So thank you very much for your for attending and for your participation today. Much appreciated.
Thank you, everyone.